Some no trespassing signs are basically lawn art that the police can ignore. You put up a fence, you posted signs, you did everything right. But here's what nobody tells you. The Fourth Amendment offers little to no protection for about 96% of private land in the US. In other words, a cop can step onto your land without a warrant and peer into your garage window. By the end of this video, you'll know when a no trespassing sign actually works, when it's just decoration, and how to turn your yard into a legal fortress that forces police to get a warrant. Let's forget about lawyers and judges for a second. Let's talk about the pizza guy rule. Imagine your house is surrounded by an invisible bubble. Inside that bubble, you should be able to do things in private without an audience. That bubble is your sanctuary. It includes your home and the small area right around it. Step outside that bubble, and it's the Wild West. This is the open field. The pizza guy rule is simple. If a stranger, like a delivery driver or a mailman, can physically walk up to your front door to ring the doorbell without jumping a fence, then the police can too. They don't need a warrant to walk where the pizza guy walks. The law has a fancy name for that sanctuary bubble. It's called curtilage, which refers to the areas immediately surrounding the main structure. Depending on the location, curtilage can include yards, porches, driveways, carports, and sheds. Curtilage is the only outdoor space that gets the same protection as your bedroom. If the cops want to search your curtilage, they generally need a warrant. Everything outside that bubble is called open fields. It's just a figure of speech because an open field doesn't have to be open or a field. And here is the problem. The Supreme Court has said that you have zero expectation of privacy in open fields. Zero. Why? Because the Fourth Amendment protects houses and not land. It doesn't matter if you put up a no trespassing sign. It doesn't matter if you own the land. If an area is an open field, the police can walk past your signs and look around. So the million-dollar question is, where does the bubble end? The courts use a 4-part test to decide if your no trespassing sign is worth the plastic it's printed on. The proximity test. How close is it? Your backyard and side yard typically have more protection than a front yard, driveway, or a shed that's 100 yards away in the woods. The enclosure test. Is it fenced in? If your special garden is inside the same fence as your house, it's part of the sanctuary. If it's outside of the fence, it's the Wild West. The use test. What do you do there? A patio with a grill and lawn chairs looks like home life. A storage lot for rusted lawn equipment looks like an open field. The visibility test. Can the neighbors see in? A yard hidden by 8-foot hedges shows you expect privacy, but a front lawn visible to every car driving by suggests you don't care. If you remember nothing else from this video, remember this. Ownership does not equal privacy. I know what you're thinking, but it's my land. I pay taxes on it. It doesn't matter unless you live in a privacy state. For most Americans, your no trespassing sign is just a decoration. In most states, you need more than a sign to stop cops from knocking on the front door. However, some states provide their residents with stronger privacy protections than the U.S. Constitution. Currently, these states include Mississippi, Montana, New York, Oregon, Vermont, Tennessee, and Washington. In these states, simply posting a no trespassing sign can, in some cases, require cops to get a warrant before entering your property. And it's not just regular cops. This open fields rule is why game wardens can wander your private land, armed without a warrant, looking for hunting violations. They rely on this rule more than anyone. Just remember that it does matter whether the officer is state or federal, because even if you're in a privacy state, a search that's illegal under state law can be legal under federal law. And even if a judge tosses out the illegal evidence in state court, this evidence can still be used in federal court. So let's talk about the one area that always matters, no matter what state you're in: the path to your front door. This is called the implied license. Remember the pizza guy rule? It's the same idea cops use for the knock and talk. Cops will knock on your door, hoping you open it so they can smell something or see something. Doing more than that, such as bringing a drug dog to your porch, crosses the line from a visit to a search. Imagine you have a long driveway with a sign at the entrance. If the police drive past it, walk to your door, and smell something suspicious, they can often justify a full search. Because there was no gate or fence, the court may rule you didn't really expect privacy. Buying a plastic sign is not the same as blocking the path. In theory, a no trespassing sign alone could stop a cop from knocking on your door in every state under the right circumstances. But in reality, some judges have argued that no trespassing signs are legally ambiguous since they're meant to stop illegal entry, not a knock at the door. Other judges have said citizens shouldn't have to barricade their homes with a fence and closed gate to protect their constitutional rights. Ultimately, using a sign without any physical barriers allows your constitutional protection to become a choose-your-own-adventure book for the police. So here is the shift you need to make in your head. The law isn't about ownership, it's about intimacy. The courts protect the areas where intimate home activities happen. The further you get from the house, and the less you physically enclose the space, the less intimate it is legally. A no trespassing sign doesn't create intimacy. A tall privacy fence does. That's why signs work best when paired with other ways to keep people out, including police. Here are some ways to make your signs stop cops in their tracks. 1. A fence with a locked gate. A fence that encloses your yard with the gate that's closed or locked is the clearest possible signal that entry is not allowed. Even courts that don't respect signs will usually respect a locked gate. Bonus points if the fence is tall enough to block the view from the street. 2. Clear signs at every entry point. Don't just put up one sign, put them at every possible way someone could enter. Driveway, walking paths, fence gates. Make them big. Make them say something direct like, private property, no entry without permission, or no trespassing, violators will be prosecuted. 3. Use the space. Use your yard. Put furniture out there. Add a grill. Make it obvious this is where you live your private life. The more it looks like an extension of your home, the more likely it is to be treated as curtilage. 4. Block the view. Privacy fence, tall hedges, trees, whatever it takes to make sure someone standing on the street can't see into your yard or your windows. If there's nothing in plain view, there's no probable cause. 5. Know your state's law. Find out if the courts in your states respect no trespassing signs or require gates. This stuff varies wildly, and you need to know what actually works where you live. And if the police do knock on your door and they don't have a warrant, you don't have to open the door. You can use an intercom or a loud voice to say, "I will not open the door. I do not consent to any searches. Please leave." This is why rich people have gates at the start of the driveway, not just at the house. By locking the perimeter, they are trying to extend that bubble all the way to the street. But even that's not guaranteed, because even if you have a gate, a fence, and a moat full of alligators, there is one magical phrase the police can use to ignore all of it. They will kick your door down anyway, and it has nothing to do with a warrant. But that is a story for the next video. If you enjoyed this video, please like and subscribe.